I will permit, Mr. Brown, I will permit you to argue your interpretation of the rule when the time comes for that.
Okay. The other ones were jurors, witnesses, attorney-client privileges. Did I record any attorney-client privileges?
I will allow that question if the witness knows.
I don't know.
So you don't have any proof that I violated the rule with attorney-client privileges? Okay?
No.
Okay. Did I record any juveniles in court?
I don't know, probably.
All right.
You're waving your camera all around in the Public Services Center, and there are children in it.
Okay, do you have proof that I recorded any juveniles in the courtroom?
That was asked and answered.
Yeah. Okay, I don't know. All right. So 122 applies mostly to media and mainstream media, correct? Because it talks about pooling and stuff. Is that correct?
No, it's not correct. It applies to anyone wishing to record in a courtroom.
That's what in a courtroom, 122, yes. So in the courthouse, that's 122.1, correct?
Yes.
And that's what you're saying I violated was 122.1, not 122, correct?
I have never claimed that you violated 122.
Yes, only 122.1.
Yes.
Okay, all right. And then in the part, just to get it straight, the part that I said that I violated 122.1 was only recording you. That's all, just recording you. That's the only thing you put on this paper. So you're not saying that I recorded other people, just you.
No. I'm filing the injunction because I know you recorded me. In your videos, you have captured other people in the courthouse without their permission.
So other people that recorded you that day, was they given an injunction against harassment?
Well, let's see, Mr. Gonzalez, yes. Mr. Peltz, yes. Mr. Freeman, no.
Mr. Who?
Mr. Spencer, no. James
Okay,
Spencer?
all right. And why wasn't he? Because you
Because I gave him permission.
Okay, all right, just making sure. Okay, so on that day,
Okay.
on January, we're still on January 2nd. Okay, we'll switch over to January 24th again. Okay, on January 24th, you also said I recorded on January 24th, right?
I do not believe I said that.
So you're just saying I was disruptive. So I wasn't, you have no proof of me recording?
I have no proof that you
Okay,
recorded.
you have
Which is
no-
why I didn't state it.
Yep, and you have no proof of Mr. Gonzalez recording?
Your Honor, that's irrelevant.
Sustained.
He alleged that Mr. Gonzalez was recording.
However, this does not go to whether you were disruptive.
Yes, and then, and same with Mr. Peltz. You have any evidence that he was recording?
That's sustained as irrelevant as well because that does not go toward whether Mr. Brown was being disruptive.
Your Honor, Mr. Brown's batting about 1 for his last 20 questions in terms of relevancy. I don't know where we're going from here, but.
Mr. Brown, what additional relevant questions, areas do you intend to explore?
Since we're only on these 2 dates, we're not on that other date where the fantasy thing happened. I am pretty well wrapping it up, but I still don't understand. I just want to know in detail everything that I did that was disruptive, other than giving the speech that you said I gave. What else was disruptive?
I'll allow that question. What else?
I want to know everything that was by detail, everything I did that was disruptive.
I would say that the video speaks for itself.
I want to know what
And
you.
We all saw the video.
Was you
We saw
standing-
We saw how you spoke loudly in the courtroom when you were not questioned. You had no business talking to that officer. I mean, he wasn't arresting you. He wasn't asking you to step outside, and you inserted yourself into that. It caused the city prosecutor to have to stop what he was doing, and along with Mr.
The city prosecutor stopped when the officer came in, before I said anything,
Okay, that's not a question, you can ask.
right? I'm asking, did the city prosecutor stop when the officer walked in?
I don't know, I'll have to watch the video again.
You just watched it, sir. That part was on
I
there.
don't have it memorized, Mr. Brown, sorry.
You just watched it several times. Okay, so the other question, was you standing right there when everything I did that was disruptive? Was you right there?
For most of it, yes, except for the part where I departed to find a judge.
Yeah. And that was in the very
Because I
beginning.
considered it, I will tell you, I considered it contempt of court.
Your Honor, I've got this repeated beeping going on here.
Yeah, that's my thing shutting off after so long, because I just have to turn it back on. The next time is gonna be 15 minutes probably, so we'll probably be done by then. But that beep is not that disruptive.
But I will say I saw enough of your behavior in that courtroom to determine that it was disruptive.
You saw nothing else what was that? I'm sorry.
I saw enough of your behavior, along with the behavior of Mr. Peltz and Mr. Gonzalez, to determine that it was disruptive to court operations.
Okay. Did you notice your officer was drunk? Did you
No,
smell?
I did not.
Did you hear Gonzalez?
Objection irrelevant.
I will sustain that would be hearsay in whatever Mr. Gonzalez said.
Yes, but he's going to be testifying. Okay. All right. So you was standing right there in the courtroom, and you just said that on the video you couldn't that I was real loud, but you couldn't hear it when we just watched it. You can't hear what I said because obviously it wasn't loud.
I can hear it in my office just fine. I can hear it on my iPad just fine.
But why couldn't you hear it
on
when
my
we
laptop
watched
just
it?
fine. I'm not responsible for their court.
Asked and answered.
Okay. So I'm just trying to make the point that you say that I was loud, but then you can't hear me on the video. That's just contradicting.
That point has been made and the question's been answered.
Okay. So the court guy, Alan, what's his last name? Alan, the court that stopped because of I was disrupting. What was his name? Alan.
Your Honor, who else was in the court besides Mr. Brown is irrelevant?
Sustained. As to the fact that there were individuals visible in the video, but unless they're going to be called as witnesses, then their identity is not relevant.
So yeah, I was going to call him as witness, and I got other subpoenas, but I didn't. I wasn't able to have the time because this came so fast. As far as I didn't have time to, they had till the 11th to do this, and it was on the 5th, so I didn't have time to do very many subpoenas. I didn't even have time to read this thing.
Okay,
much,
so we'll address that when we get to the point where you're calling your witnesses.
Okay. Is the state putting on any more witnesses besides Mr. Hale?
Well, first of all, we need to determine if you have any more questions for Mr. Hale.
Yeah, okay. All right. I think that about covers it.
All right. Any redirect for Mr. Hale?
Sure. Mr. Hale, I'd like to ask you some questions about this, the incidents that are listed in the injunction. The first one is, Mr. Brown recorded you without your express consent, right?
Correct.
The second one is that Mr. Brown acted in a fashion depicted on the video during the courtroom proceeding on January 24th, 2019. Is that correct?
That's correct.
And on January 25th, on June 25th, Mr. Brown, as part of a First Amendment strike team, came up to you and told you that his injunction was up and we would be back in city court as soon as he was no longer restricted by the injunction. Is that
That's correct.
So we've got 3 different occasions where you saw Mr. Brown in city court.
He was outside of city court.
But you saw in the direct interactions with
Yes.
Mr. Brown. In addition, I'd like to ask the question about, there were some questions from Mr. Brown involving an injunction against harassment and also an injunction against workplace harassment. Are you aware of the opinion of the court of December 26, 2018 in that injunction against workplace harassment matter?
Was that Judge Gordon's?
Yes.
opinion? Yes.
I'd like to introduce that as the exhibit 2 of the plaintiff's case, Your Honor.
All right, any objection?
Yes, sir?
Okay, that's it. That's plaintiff's exhibit 2.
You also testified that there's a legal opinion that's been circulated by the courts clarifying whether court employees are individuals with respect to Rule 122.1 and 122 and the rest of the court rules. Is that correct?
Correct.
I've got an opinion that's from the Administrative Office of the Courts to Marcus Rankensmeyer, Director of Court Services Direction, from David Withy, Chief Counsel, dated March 7, 2019, regarding the application of Rule 122.1 to court employees. Is that the opinion of legal counsel that you're referring to?
Yes. It is.
I'd like to introduce this as the plaintiff's exhibit 3.
I'd like to see it, sir.
Okay, look at it.
This is dated March 7th, after that I was served this thing.
As I previously,
I would like a copy of this.
My clerk can make a copy of it.
and as I previously stated, Your Honor, I had been in verbal contact and email contact with Mr. Withy, and had confirmed that Rule 122.1C applies to court personnel prior to the May 30th incident, based upon an individual named Roger Ringer, who was at our court recording people on May 7th, I believe, which then caused me to do some research and coordinate with the Tucson City Attorney's Office and the Legal Services Division of the Arizona Supreme Court to clarify whether the rule applied to court personnel or not.
You also testified earlier that you changed the sign on the court response to an order from Judge Tony Riojas.
I did.
I've got what I've marked preliminarily as plaintiff's exhibit number 4. There's an order from Judge Riojas dated the 5th day of June 2019. Is that the order you're referring to?
It is.
Your Honor, I'd like to admit this is plaintiff's exhibit number 4.
Is plaintiff moving to admit exhibit number 3 as well?
Yes.
All right, any objection to exhibit 3?
I don't know what he has it in, so I'd like to see it. And of course, want a copy. So
And
get-
again, I will add that that order is the model template, or the model administrative order recommended by the Administrative Office of the Court to be used in all courts in Arizona, excluding federal court.
Yeah, I objected. This is in violation of Rule 122.1.
Okay,
The sign is too.
Okay, I will note the defendant's objection. You've preserved that issue for appeal. I will give it the weight that I feel it deserves, but I will show that over defendant's objection, plaintiff's exhibit 3 and 4 are admitted.
Oh, thank you. Thank you.
Mr. Hale, how long have you done your job as the Tucson City Court Administrator?
I believe since 2011.
And during that time period since 2011, just, can you give me a rough estimate of how many people, how many citizens of Tucson walk through the courts?
Actually, I can't, because I brought a spreadsheet. Since 2011 through April of 2018.
Relevance, Your Honor.
2,533,000.
Objection, relevance.
People have come through the doors.
I find that this is relevant as it relates to how many people might have been captured on photographs.
So,
The witness may answer the question.
And
2,553,750.
And how many people have you requested injunctions against workplace harassment against for violation of Supreme Court Rule 122.1C?
Mr. Brown, Mr. Peltz, Mr. Gonzalez, and Anthony Potter.
So
Four.
2.2 million people have come through Tucson City Courts and you've requested order of injunction arrestment.
2.5 million. I
2.5
requested
million have
4.
come through city court and you've requested injunctions against harassment against 4.
Correct.
I have no further questions.
And I will add that I've only had instances of anyone having issues with recording those 4. Well, 5, including Mr. Ringer.
All right, thank you very much, Mr. Hale. Please watch your step issues.
I can recross on the question.
There is no recross in the state of Arizona. So, Mr.
He just mentioned the First Amendment strike team, and that's a total lie. So I need to address that, sir.
There is no recross in the state of Arizona under the rules of evidence. That just doesn't exist. Does the plaintiff have additional witnesses? It's now 4:43.
Yeah, I'd like to ask a few questions of Mr. Brown that I think will, if the answer's the way I think he will, probably take care of the case pretty quickly.
I object.
All right, Mr. Brown, you stated that you did wish to testify.
I'm going to testify, but it's going to be after I bring my witnesses if I need to. If my witnesses can do what I have to do, then I'm going to do it with my witnesses. But I probably will testify after.
Mr. Brown, this is a civil case, so if you are concerned that you might be admitting to something that would implicate your Fifth Amendment right against self-incrimination, I will appoint Fifth Amendment counsel to advise you on that, and you can decide whether or not to invoke. But this is a civil matter, so the plaintiff does have the ability to call you as a witness. Are you saying that you have concerns about your Fifth Amendment right against self-incrimination and you would like Fifth Amendment counsel to advise you?
No.
I do not intend to inquire about any potential criminal acts on Mr. Brown's behalf.
Okay, then the plaintiff does have the right to call you as a witness in the event that you feel there is a Fifth Amendment issue and you feel that you need Fifth Amendment counsel, then you can let the court know, but the plaintiff does have the right to call you as a witness. So this is not a criminal matter. If this were a criminal proceeding, then they would not have the ability to do that. That is the way that the rules of procedure are set up because this is a civil case. They can call you as a witness. So you did raise your right hand when to be sworn at the beginning. So
I said I was going to, but I didn't. I never raised my right hand yet.
all right, then would you please raise your right hand and be sworn? Do you swear?
Because of what Christopher Hale did to me, Your Honor, I can't raise my right hand anymore. I can't do more than this with it. I just had it out of a sling
All right,
yesterday.
in that case, if that's the best you can do you swear or affirm to speak?
I can do my left hand.
That's fine. Do you swear or affirm to speak the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right.
Yes, Your Honor.
Well, have you please make your way up to the witness and please watch your step as you step up there. All right, go ahead. You may begin questioning.
Mr. Brown, can you state your name for the court?
Mark Brown.
And I'd just like to ask you, first a general question, Mr. Brown. Do you consider yourself to be a law-abiding citizen in the United States?
Yes, sir, I
You
do.
try to follow the law and the rules as they apply to you?
Yes, sir, I do.
And do you specifically try to follow the rules of Arizona Supreme Court Rule 122 and 122.1C3, isn't that
I
correct?
absolutely did.
And the reason that you believe that you continually follow those rules throughout your life, you never intentionally violated them?
Rule 122.1, I didn't violate it as per, I didn't violate that as per the correct reading of it.
Right, and you have taken photographs of Tucson City Court employees in city court without their permission, isn't that correct?
Christopher Hale? Yes,
Yes.
I have.
And other city court employees?
On January 2nd, we're talking about?
I'm asking you in your entire
I
life.
objected, my entire life,
You have taken-
we're talking about January 2nd.
I'm asking you whether you've
I
taken
object.
photographs of,
Because he's talking about, we're
Okay,
talking about January 2nd.
I will allow the answer as to on January 2nd or on January 24th.
on January 2nd, did you take a video of Chris Hale in Tucson City Court?
I might have.
Okay?
I
And
might have, I'm trying to
so,
think, I don't remember.
so you took a video of Chris Hale on or about,
I'm
on or
not sure I
about
did.
January 2nd in Tucson City
I
Court?
didn't say, I said I might have, I don't think I
Okay.
did. I'm gonna have to,
But you also testified that you've never intentionally violated Rule 122.1C3, correct?
that's correct.
And the reason is because you think that because Mr. Hale is the administrator of city court, he's not an individual covered by the rule, isn't that correct?
Yes, he is exempt, as it says in the
No
rule.
further questions, Your Honor. I'd like to
He's
move for
exempt.
summary judgment on this matter.
Okay, you may be seated, Mr. Brown. Because, so, Mr. Brown, I want to explain what's happened here. So, because this is civil in nature, the plaintiff is requesting for summary judgment. However, I do find that the defendant admitted to what I would find to be one act of harassment. I do not believe that he admitted that he was disruptive on January 24th. So I only have one act of harassment. So at this time, based on that, the motion for summary judgment is denied. It's now 4:48. Are the parties available on Monday? That is the 8th at 10:15 in the morning.
Your Honor, Mr. Brown is
I am.
the reason that for this motion is that it's very clear that Mr. Brown is not arguing about conduct. He's arguing about his legal interpretation of this rule. And
It's one of the things.
And his legal interpretation of this rule has already been foreclosed by the opinion of Judge Gordon on December 26, 2018, which applies directly to him. It's res judicata in this case because it applied to him in an injunction against workplace harassment. So what we've got are 3 incidents here. Even if you disregard any evidence at all about the January 24th incident, you have Mr. Brown video recording Chris Hale in city court. You have him declaring his intention to continue to return to city court and record Mr. Hale or his court employees. And the reason is because, as
Not
Mr.
proven.
Brown just admitted on the stand, he doesn't think court employees are individuals for purposes of the rule. That's sufficient to support this injunction. All we're asking for in this case, Your Honor, is an order, just like the one that was issued in December, that was upheld in December 26, 2018. And the rest of all this information is just follow. The reason that Mr. Brown violates the rule is not because he thinks the rule applies in a certain place and doesn't apply somewhere else, or that he doesn't go into city court and record people. It's because he thinks he's entitled to record court employees, and Mr. Hale in particular, because of his reading of the rule. So this is a plaintiff, this is a person who's going to continue without an order that requires him to specifically comply with the rule and prevents him from recording people at city court without their consent, who's going to continue to violate the rule. And it's a perfect candidate for an injunction against workplace harassment. And it doesn't violate any First Amendment rights on Mr. Brown's part. We can dispose of this case now. There's no additional evidence needed in order to establish
I object.
the injunction against workplace harassment.
And I do find that I agree, if this were an order of protection, then that would be the case. But my finding is very specific, that the January 2nd incident, which was what was corroborated and was admitted to, which I do find is a violation of the rule and does constitute an act of workplace harassment. However, I do not believe that the defendant's testimony constituted an admission to the January 24th incident.
Okay.
I will limit the defendant's case to the January 24th incident, and it is because I need to find 2 or more separate occasions, so I do not believe this record is sufficient to do that on both matters, but I will limit the defendant's case and the defendant's witnesses to the January 24th incident. So we'll come back on Monday at 10:15 in the morning.
Thank you.
Thank you.
10:15, Your Honor?
Yes.
Excuse me,
Oh.
Your Honor?
Yes.
This flash drive that we showed, I'm assuming that you need it as exhibit?
Yes, we would. Thank you very much. My clerk can take that.
Oh, and Your Honor, also, I'm gonna be recording again on Monday. Can I have, do I have to put in another motion, or can I do that right here?
I've already granted your motion, and we're standing at recess. It's not a separate hearing. Okay.
Okay, so I can
It's a
record them?
continuation of the same hearing, yes, you can, just
Thank you,
like,
sir.
just like when we came back after pre-trials, it's just a continuation of the same hearing.
All right, thank you, sir.
You're gonna have to reject it, because I can't get in.
GoPro, turn off. GoPro, turn off.
Okay, thanks.
Oh,
Yeah. This is the little cap. It's the little cap for the flash drive.